And the next feature of the Indian Constitution is DPSP, that is Directive Principles of State Policy, which are being incorporated under Part 4, Article 36 to 51. What is the purpose of DPSP? What is the main objective of DPSPs? As in the name, as it indicates in the name itself, that is Directive Principles of the State Policy, these particular articles gives direction to the government how to function. Means on what principles, on what basis a government should function, how it need to legislate, while ruling, how, what all points it need to keep in mind, or the principles to be keep in mind is being discussed under this Article 36 to 51. Please understand, Part 3 fundamental rights are rights given to the people, as well as whereas Part 4, that is Directive Principles of State Policy, are giving directions to the government. Now, as I told you, now please understand, this is the beauty here. When a government frames a law according to Article 36 to 51 or according to the principles mentioned under Article 36 to 51, and if such law is violating your fundamental rights as mentioned under Article 14 to 30, you have a power to approach judiciary, and in such cases, obviously the winning hand would be by fundamental rights. Till now, most of the times fundamental rights are having winning hand over DPSP, except in few exceptional cases related to the land reform, related to right to property, which we will discuss in the later lessons. Now, this is the best feature is that one side you are giving directions to the government, at the same time you are controlling the government, saying that you have a limitation that you cannot make a law which is hurting the fundamental rights of the people. Now, see how fundamental rights is acting as a check to DPSP, right? It's balancing the ultimate, unlimited power of the government. Now, these directive principles of state policy have been framed up or been headed under three main headings. One is, the first one is socialistic principles, second one is Gandhian principles, and the third one is liberal intellectual principles. In the senses, some of the directions given to the government are based on socialist principles, some of the directions given to the government of India are based on Gandhian ideology, and the third one is liberal intellectual principles, where we have to think beyond, not the regular meaning, we have to think beyond, we need to look beyond, that comes under liberal intellectual principles. I will give example of each and every principle, one example, and anyways we will discuss further in the coming lessons. One example for socialist principle is Article 38, which speaks about equitable distribution of resources among the people. Resources in the senses we have, it can be any kind of resources, it can be natural or man-made. Natural resources, they need to be distributed among the people equally. Now, why the question of equally is because all people, it is the responsibility of the government to look or treat everyone equal. So, obviously, this is headed under socialistic principle, means whenever government frames laws, it need to look out whether such law is guided under socialistic principle or not. Likewise, we have one more principle, that it is the responsibility of the government to provide free legal aid to the poor under Article 39 capital A. Now, why free legal aid to the poor? Please, socialistic means available to all. Now, in India, the legal services like advisors or advocates are available usually. It's a cost involved process. So, these services are usually bared by middle class people and above middle class people. But when it comes to poor people, they cannot afford these kind of legal services. When they cannot afford these kind of legal services, it is not possible for them to get justice, which is not correct. Means since in a country like India, we need to look after for the inclusive development of all the people, we need to look after the poor also, which comes under socialistic principle. That is the reason under socialistic principles we will have Article 38, which speaks about equitable distribution of resources, and we have Article 39A, which makes sure that free legal aid is being given to the poor people, so that justice is reachable to all, and making sure that justice is not confined only to group of people, right? And example of Gandhian principle, very simple. Gandhian ideology is based on non-violence and rural development. Organizing village panchayats under Article 40 will come under Gandhian principles. Means Gandhiji has emphasized on the development of rural areas. He he said that if the rural areas are growing, obviously the whole country will grow. If you want to make sure that the rural areas are growing appropriately, we should make sure that we have political development, which is nothing but we need to organize things properly. To organize those things or to channelize those things properly, we need village panchayats. Such organizing of village panchayats is being called as Gandhian, is categorized under Gandhian principle with article number 40. Now, the last category, that is liberal intellectual principles. As I told you, we need to look beyond the general principles. Example is article 44, which talks about uniform civil code, which is very popular in news in the recent times. What do you mean by uniform civil code? In India, laws are of two types. We have criminal law and civil law. Civil laws are not same for all religions, whereas criminal law is same for all religions. In the sense is, the matters related to civil cases, that is marriage, divorce, property distribution, are based upon the religion you are, whereas criminal laws are same for all religions. Means murder is same for all the communities, there is no exception. But whereas related to marriage and divorce, it differs from religion to religion. Example is, we know that in Hindu, according to Hindu Marriage Act, a Hindu person can marry a person once. He cannot go for second marriage as long as his spouse is living, and also as long as they are together. Means two marriages are not accepted in Hindu marriage law when the first wife is there. It applies even to men also, right? I mean, a female cannot marry a second person when, as long as she is engaged to one person, or as long as her husband is alive. According to Shariat law, that is Muslim law, a man can marry 4 women with the permission of his previous wives. Now, this is a very, very complicated situation. Now, what happened is, most of the people who belong to Hindu community or Hindu religion, they got converted into Islam and they got married with the other partners. Now, this is like using the loophole of the other religion. Now, because of this, many issues have cropped up, and Supreme Court in many cases like Sharda Mudgal case, and as well as in the Mohan case, has stated that there is a need to implement uniform civil code in India. So, that particular thing, which is like one religion, one law, is general, but looking beyond it, that is all religions to have same law, all religions to follow the same law, is something very broader notion, which comes under liberal intellectual principles under article 40, right? So these so that is how directive principles of state policy, it's very planned, it's very beautifully planned in our constitution. So this feature also is a unique feature of Indian constitution. Moving on. The other feature what we have in our constitution is fundamental duties. It's something very different. Initially, when we have framed up our constitution, or when we have adopted our constitution in 1950, we never had the concept of fundamental duties. Fundamental duties are being incorporated in our constitution by 42nd CAA, that is 42nd Constitutional Amendment Act 1976, based on Swaran Singh committee recommendations. Means, why we didn't have fundamental duties is, government didn't insist of having fundamental duties compulsory. Compulsory in the sense is that it should be there. It expected people to be automatically have that conscience to follow some duties and all. But there was a need, but the government in later stages felt that there is a need for us to document even this issue. That is the reason they have incorporated the chapter called as fundamental duties under part 4 A, part 4 capital A, under article 51 capital A. Probably by this time you might have heard me saying once or twice capital A, capital A. When you open the constitution, this is one of the important thing. When you open up the constitution, you will see article numbers. Article numbers are nothing but the rule numbers with small letters as well as capital letters. Small letters are denote the clauses in the same article, whereas capital articles, that is capital alphabets, that is capital A, indicates it as a separate article. Example, article 21 and article 21 capital A. Though the number is same, they both are different articles. This is what you need to understand, right? Now, means whenever you see a word capital, You have to understand that that particular point was not there when the constitution was written. It is being incorporated in the later stages. Likewise, fundamental duties under Article 51 capital A under Part 4A have been incorporated by 42nd CA in 1976 based on Swaran Singh committee recommendations. Now, we have picked up this concept of fundamental duties from Russia. In Russia, fundamental duties are mandatory. But in India, fundamental duties are not mandatory, means though we have mentioned it in the constitution, still fundamental duties are made as a voluntary thing instead of making it compulsory. This is the different structure we had when compared to the other countries. As I need to mention you, even our directive principles of state policy, they are not justiciable in the courts, means you cannot challenge a government stating that it didn't follow so and so article number as mentioned under DPSP, means you cannot approach the courts. But whereas fundamental rights, please understand the difference between Part 3, Part 4 and Part 4A. Part 3 fundamental rights are enforceable by the courts, means you can approach the courts if they are not getting implemented. Part 4, that is directive principles of state policy, are not enforceable by the courts, means you cannot challenge them in court, you cannot challenge the government in the court saying that they are not being implemented. And whereas Part 4A, that is fundamental duties, even they are also not enforceable in the courts, they are not justiciable, they are made voluntary. Unlike Russian constitution, our constitution made fundamental duties to be just an voluntary option. It's voluntary, it's not a compulsory thing. And the next feature of our constitution is, our constitution ensures secular state. Okay, means our constitution of India stands for secularism. How can you say that Indian constitution stands for secularism? Indian constitution stands for secularism by making sure that Article 25, if you see Article 25 to 28, as I discussed you, it ensures right to religious freedom, means being a citizen of this nation, I have a right to follow the religion of my own choice, which is nothing but government is not bothered about my religion or my religion of choice, means it doesn't look out, it doesn't treat me unequally based on my religion. So, which means that Indian constitution is making sure that secularism is being present in India. But the thing is, this word of secularism is not mentioned in our preamble, that is the 4 word, when we have adopted the constitution. This word secular is being inserted in the preamble in the later stages by 42nd CAA in 1976. Why they haven't incorporated till 1976 is the constitutional framers thought that though we don't incorporate the word secular in our preamble, still the constitution exhibits that secularism. But in 1976, due to the issues, they have incorporated the word secular, they made it mandatory in the preamble, right. So, and also the other characteristics which reflect Indian constitution to be secular is, we need not pay any religious tax, as we know. And the other thing is, irrespective of your religion, you have the right to contest for any post, like you can contest for presidentship, vice president, prime minister, ministers. You can become a CAG, you can become a Lok Sabha member, Rajya Sabha member, irrespective of your religion, which is nothing but what? A secular characteristic. Now, subject to the conditions, you should have the other prescribed qualifications for that particular post, or else you would not be denied because you belong to one particular religion. I mean, this purely says that Indian constitution is secular in nature. I'm talking about books. Practically it is a different story, but anyways, by books we are secular. And also, the next beautiful feature of our constitution, moving on to the other part of our constitution, is we have a universal adult franchising. In the senses, what do you mean by universal adult franchising? We being a democratic nation, we have the right to choose our leaders. Now, how you are going to choose your leaders is by giving voting. Our representatives, how we are going to do that is by, voting. This voting power is nothing but called as adult franchise. It's nothing but adult franchise. Initially, in India, during the Britishers' time itself, adult franchise was very limited. It was given to those people who, used to pay taxes, rich enough people. Women were never given this right, only men of few groups only were given the right to, vote. But when we got independence, our constitutional framers made sure that these voting rights are available for each and every person in the country. That is the reason you call it as universal adult franchisee. You don't call it as adult franchisee, we call it as universal adult franchisee. Is universal in the sense as those who are all above a prescribed age, they have the right to vote according to our Indian constitution. Now what is that age? Till 1988 somewhere, the definition of universal is those people, those adults who are about 21 years have the right to vote is being there. But the later stages, that is by 61st Constitutional Amendment Act 1988, 61st Constitutional Amendment Act 1988, it changed the age from 21 to 18 years. Means now in today's time, or as on today, universal adult franchisee means those people or those adults who are above 18 years, or those citizens, I should say, not even people, those citizens who are above 18 years are having the right to vote. Now the question is, what is the, what you have to derive when this age is being reduced from 21 to 18. The age reduced from 21 to 18 is, it shows us that the scope of democracy has increased in India. Because let's suppose if the people are more than 21-year-old, we have 1 lakh people. But when you make the voting rights above 18, the number of voters would increase. Let's suppose we have 2 lakh. Means, is there an increase in the people participating in the elections or not? Voting or not? Yes. It means what? The scope of democracy has widened in India. This is what you need to derive. Means, for UPSC kind of examinations, you have to derive this. For the other examinations, you need to focus of which amendment, which year and all. So, universal adult franchisee in India means above 18 Indian citizens have the right to vote, This age of 18 years was decreased from 21 years by 61st Constitutional Amendment Act 1988, right. So, this is one of the unique feature of Indian constitutions. Please understand how it evolved. We never had it initially, females never had. Initially when Britishers were there, zero franchisee. Later they started giving rights only to, voting rights to only those who pay tax, or rich guys and all. Females were never there in this game. After independence, we started giving to everyone whoever crosses 21 years. Now today it is 18 years. How it changed it to 18 years is by 61st Constitutional Amendment Act 1988 under Rajiv Gandhi leadership. Next, the other feature, the other beautiful feature what you can witness from our constitution is, we had single citizenship. What is it unique? It's definitely unique. When you look out for United States of America, United States of America is nothing but federation of 50 countries, right? Now, you will have 2 passports when you travel to US. One is United States of America passport, and the other country where you are living in, you have 2 passports. Means you have dual citizenship over there. Whereas in India, we have single citizenship. That is, you will have only 1 passport called as Republic of India. Means that passport entitles you to travel anywhere within India. I mean, though we don't carry, it means that we are all, all the people of this country are same, equal, right. So, that is a different feature. I mean, see, we have picked up, we borrowed many unique features from American Constitution. Likewise, we didn't borrow the dual citizenship concept from United States. We have gone for single citizenship concept from UK, right. So, if you have Republic of India passport, even if you don't have a passport also, you are entitled to travel anywhere in India, right. You cannot say that and there is no such concept called as states having separate citizenship, etc., etc. No, there is no such concept. That is the reason single citizenship reflects the unitary feature of Government of India, okay. And the next other feature is we have a very unique concept. This is also very unique, bicameralism. As I told you, the concept of bicameralism is being picked up from United Kingdom, that is British Constitution. Now, the twist here is bicameralism is compulsory only for central government, whereas bicameralism for state government is optional. In the senses, having lower house, that is Lok Sabha and Rajya Sabha, is mandatory for parliament, but there is no such obligation that you should have two houses in the states. That is the reason you don't see MLCs in all the states. Only few states, I suppose it should be 6 or 7 states, are having MLCs in India. That is where actually UPSC twists your question paper, because all the students will not be aware of the state legislature concept. They will not be able to relate, because some states don't have this MLCs, some states do have MLCs. This is where you will have confusion, right? Central government every person knows about central government, but when it comes to state government, this is a difference. So, bicameralism is being borrowed from the British Constitution. Please make a note that bicameralism is compulsory only to the central government level. Bicameralism is not mandatory for the central government, for the state level. But you need to understand why only MLCs, why don't we have, why only we shouldn't have upper house, why can't we stop having lower house? Please understand, direct democracy in India is ensured by our direct representatives. That direct representatives are nothing but called as MLAs. So, obviously, every state in India, every state in India will have MLAs, but they will not have MLCs. So, bicameralism is just an optional at the state level, whereas it is mandatory at the central level. This is one of the best feature. It is also very unique, right? And moving on to the next feature, we have emergency provisions. Emergency provisions. This is what we are seeing nowadays, very recently, nowadays in the papers and all, we see that the alliance between BJP and PDP is broken. You see that Garner rule coming in picture. What are all this? These are called as emergency provisions, and I think it's a day of emergency imposed by Indira Gandhi in 1972, right? Now, what do you mean by emergency provisions? Emergency provisions, when the situations of the country, when you feel that the situations of the country are not proper, there is a need for us to control the law and order, the situations, making sure the welfare of people. Now, how we are going to do this is by imposing emergency. What kind of emergencies we have? We have basically 3 types of emergency. You can see the classification. The first one is a national emergency as being declared under Article 352. The second one is presidential rule, which will be imposed under Article 356 for breaking up the rules mentioned under Article 365. So, please don't get confused. Again I repeat, presidential rule is imposed under Article 356 for breaking up the rules mentioned or the provisions mentioned under Article 365. So, for presidential rule, we need to read out both 356 and 365 together. And the third one is a financial emergency, which would be imposed under Article 360. So, these 3 types of emergency provisions are there. These are the extreme situations when a government will try to control the whole country based on the need, okay, in a different manner. As the name title, national emergency in the sense is in an rebellion conditions, unforeseen situations and all, the central, and please understand, all these emergencies will be imposed by the central government only, not directly by Prime Minister. Instead, they will make it announced by the President. Okay. And once these emergencies are imposed, whatever the area, wherever they have declared, that comes under direct the central government rule, that is presidential rule. The President will be taking care of, or the central government would be taking care of, right? And as I told you, during these emergency conditions, not all, but during national emergency and we will see suspension of fundamental rights, which we have borrowed from Germany. Okay. So, this is also one of the unique concept we have, that is emergency provisions. And the last feature of our constitution is we have 3-tiered government, in the sense is When I explained your syllabus, I have shown you we have three forms of government, three tiers of government. One is union, state and as well as local. I mean local government. Local governments are nothing but categorized again as panchayats and municipalities. Now all these governments are all these governments will be, all this level, these three tiers of the governments will be monitored by the respective governments. In India, when we have adopted the constitution, we never had the concept of third tier government, three tier government, that is the third tier government. We had only the reference of central government and the state government. But the third tier government, that is the local government, was being incorporated or inserted in our constitution by 73rd Constitutional Amendment Act 1972 and 74th Constitutional Amendment Act 1992, same. 73rd and 74th Constitutional Amendment Acts 1992 have inserted panchayat and municipalities in our constitutions respectively. So till 1992, though we had an informal setup of third tier government, we never had a constitutional setup of third tier government. The constitutional setup of third tier government or three tier government was incorporated by very famous one, the 73rd Constitutional Amendment Act 1992 and 74th Constitutional Amendment Act 1992, which incorporated panchayat, which has given constitutions which have upgraded a normal panchayats and municipalities to constitutional level by these amendments. Now, once you upgrade the system from a normal position to a constitutional post, it ensures they are being implemented and you have a right to question them why they are not being implemented. We can challenge the government why they are not getting executed. So, and when it is a constitutional position, please understand they will have more power to function, they will be given good money to support also, right. And the last feature of the constitution, that is independent bodies. In India, we have organizations to make sure the governance runs properly, right. Now those bodies are being categorized into two. One is constitutional bodies and the other one is statutory bodies, as you can see in the slide. Now these constitutional bodies and statutory bodies are independent in nature. Though they are within the framework of the government, still these bodies are being given autonomous powers for their functions or their objectives. Example, CAG, Comptroller and Auditor General of India. It is a constitutional body under Article 48, but it is having that autonomous power to exercise, to look after, to audit all the government, government accounts, whether the amount given to them are being fulfilled or not. Now that is the best feature, means they are part of the government but still they are being made as autonomous. This is a very unique concept. You see this, these kind of all these features you can identify when you go through the Indian Constitution. That is what is this chapter, salient features of Indian Constitution. Hope you understood. We'll move to the next chapter in the next video, that is preamble. Thank you.